be seated, please. Yes. Mr. Setti.
Thank you, Your Honour.
Mr. Setti, if I may, please.
The witness wishes to
Yes, Mr.
address
Mahmood.
me or the court.
The call.
Yes,
See?
Mr. Mahmood.
Your Honour, I'd like to seek permission to make a correction, I believe, to one of the responses I made yesterday, if that's possible.
Mr. Setti, do you have any objection to this?
I don't know what it is about, and until I hear...
Well, it's best you hear probably while you're cross-examining than
Quite.
hear it in re-examination. So, Mr. Mahmood.
Late yesterday afternoon, forgive me if I'm paraphrasing and my paraphrasing isn't correct. If it is, please correct me. But yesterday, Mr. Setti, late in the afternoon, asked me a very focused question on who was responsible for the conspiracy to get rid of me.
Yes.
And in my mind, I believe that question to relate to decision makers. Right? So I gave him 9 names. If it was a wider question that related to people who were responsible in terms of influencing, there's a very obvious group that I forgot to omit, which was the 4 people who made those speak-ups against me.
Right.
And anyone else. So just for clarification, correction, I don't know which one, but...
Thank you. Well, there it is, Mr. Setti. You can do what you wish with it.
So do we understand your position to be that in addition to the 5 people you identified in the GIB department and the 4 people you identified in the compliance department, there are an additional 4 people potentially who are the people that brought the 4 complaints against you?
2 of those were anonymous. That could have been multiple individuals or a single individual.
Yeah, but the whoever was behind the,
Yes.
the 4 complaints against you.
And could I
So we're
say-
now, just so we're clear, we're looking at potentially 13 or so targets of 13 perpetrators of discrimination, 13 co-conspirators. Yes,
And potentially more, depending on what comes
potentially
out,
more.
depending on what comes out in cross-examination. Yes.
Well, I actually just want to know what your case is. The case we normally have to understand before cross-examination begins, before even the trial begins, before we even prepare for the trial and disclose documents and prepare statements. So, are we talking about 13 co-conspirators, or are we talking about more than 13 co-conspirators?
My case is that I was subject to discrimination within GIB and within the compliance management framework structure. You asked me a very focused question on who was responsible for removing me from the organisation. I took that to mean decision makers. I'm aware of some people who may have influenced that decision, but as is apparent, I think as was touched upon earlier in this case, it's not always apparent in a discrimination case who was actually doing stuff behind the scenes. Now, I don't want to basically limit my counsel's ability to actually delve into that when he's cross-examining witnesses. So there may be more. I can't tell you, Mr. Setti.
That's an unfortunate position to be in if you can't tell me who the alleged discriminators are, according to your claim.
Well, I've given you 13. There may be more.
Yes, well, let's treat that as deal with that in submissions. Your Honour, I think that it might be the best way to deal with it. I don't think we're going to get anywhere further with that now. But so, Your Honour, I will be exercising my right to make any objections should the case be sought to be broadened by my learned friend, despite the evidence of this witness, or in view of it. Your Honour, there's one matter that before cross-examination was to continue this morning that I wanted to clarify, if I may, and I think we should deal with it firstly, because it's a matter potentially of some importance. Yesterday, Your Honour was clarifying, just shortly before we broke for the long adjournment overnight, you sought to clarify the position in relation to the defendants' witnesses that would give remote testimony to the court, and we identified who they were. And Your Honour made reference to the term sequestration of witnesses. Of course, Your Honour observed yesterday that there has been no order for sequestration
Yes.
of witnesses in this case, and Your Honour will have observed that the defendant's witnesses, as no doubt the claimant's legal team fully well knows, the claimant's witnesses, the defendant's witnesses, some of whom have been present in the courtroom, observing the proceedings from the very beginning.
Oh, I wasn't aware of that.
Well, we were taking instructions from on the
Yes,
availability of Mr. Long and Mr. de Groot yesterday in Your Honour's presence, for example. So, the other side have been aware of this. No application has been made
Yes.
for sequestration of witnesses. So in the first instance, I just wanted to obtain some clarification as to Your Honour's position, because it came as some surprise. If it would come as some surprise to us if that is something that's now being raised.
Well, I'll hear from Mr. Bigford-Smith.
Well, the first comment is I'm slightly caught on the hop by this, because my own position on this was, and I will take instructions. Of course, I can't take instructions from my client, but my own position on this is as follows. First, with regards to the fact that witnesses of the defendant have seen the claimant's testimony, whether online, in court, or so on, there's no objection at all to that. There's nothing, there's no problem about that. With regards to the defendant's witnesses, if I may respectfully say so, the position Your Honour stated is eminently sensible. This is quite clearly a case where...
well, I don't think I did state a position, Mr. Bigford-Smith.
Yes.
I wanted to know what the position was.
Yes.
But anyway.
But insofar as necessary, we would seek an order to that effect, yes.
All right, thank you. Mr. Setti?
So I can understand why my learned friend might want to jump on a suggestion that's been prompted for the first time at this juncture by Your Honour, but I would make the following submissions. Given that now an application has been already made. Now, Your Honour, you've observed firstly that no order has been made to date, and if an order to that effect was to be made, the normal process, of course, for one party or other to make an application. Of course, that doesn't prevent a judge of their own motion from potentially exercising a discretion to make some kind of order to this effect. So that's the first point. The second point is, of course, there's a fundamental principle of open justice in relation to proceedings, including discrimination claim in proceedings of this kind. And that's in accordance with principles of fairness to the parties.
But
and
that's...
the normal...
Sorry, Mr. Setti, that's based on proceedings being available to the world at large, not
Yes.
in relation to prospective witnesses.
Well, it's generally speaking, but I agree with that proposition. The target of that principle is fundamentally that. But the normal practice, of course, in cases is not for there to be some blanket witness exclusion during trials of this kind.
Well,
and that's why...
The practice
that's why
I'm familiar with, Mr. Setti, the practice I'm familiar with in my home jurisdiction is that if there are any credibility issues, an order for witnesses out of court is invariable.
Yeah. It's quite the reverse in England and Wales.
Right.
Quite the reverse. The norm, and in fact it's rare for, even in cases where credibility is an issue, rare for employment tribunals in England and Wales, for example, and courts to exclude witnesses. So the default position, the norm, is that there is no such witness exclusion principle as a default or as a normal practice, even where matters of credibility between witnesses is in issue. The next, so that there is a difference between perhaps Western Australia and England and Wales. Now, of course, the rules, both the procedural rules of this court and the substantive law on discrimination, appear to be somewhat modelled on the English system. That's so one would have an expectation that the way in which hearings are held and conducted, that there would be some parity, although, but that's of course not a rule, but just as a form of approach. The next point is, of course, that there is, I've checked the rules of this court, they are silent on the issue. The rules of the English and Wales employment tribunals are not silent on this issue. They assume that there is a default position whereby witnesses are in full attendance throughout, but there is an express rule in the employment tribunals, which is contained in Rule 43, whereby if a tribunal considers that it is necessary in the interests of justice to exclude a particular witness at a particular time, then there is a discretion that can be exercised there. So it's not as if it's not heard of. But the norm, and as I say, it's rare in England and Wales for even where there are matters of credibility at stake, for there to be witness exclusion. And the same approach applies both to in-person hearings or hybrid hearings or remote hearings, of course. Now, a decision to exclude a witness must be taken, and certainly the practice in England and Wales is that it must be taken on a case-by-case basis and on a witness-by-witness basis, applying this test of whether a particular witness should be excluded at a particular time or period of time is necessary in the interest of justice for that particular case. So just pausing to reflect on that, the position is that you don't have a blanket exclusion order. So even when an order is made, it's a very specific order that's made for a particular witness.
Well, that might be the practice in England and Wales.
I entirely
it's
accept
not the practice in...
I'm simply using that as the one known experience that one has of how these matters are dealt with. I don't say that dictates the practice here, Judge, for a moment, not at all. It's simply the practice of the jurisdiction upon which this jurisdiction has borrowed significant procedural ways. Now, when such an order is applied for, is usually before the start of the hearing, part of the housekeeping, part of the agreements between the parties, and it need to be made really at the start. Now, I hear my learned friend's point that he takes no objection to what's happened so far. That's helpful. But we are now into day 3, and I think it is only right, it's only sensible and appropriate that I raise this at this stage, so we're very, very clear, both sides, as to what the position should be going forward. So as I say, what is strange in this case, until your Lordship raised it latterly last night, it hadn't been raised by my learned friend at all. And I do say that if he had seriously considered it of his own motion, he would have made that application. He's only jumping on a particular bandwagon now, if I can put it like that, respectfully, because of your Lordship's suggestion yesterday. So, and that is a relevant consideration, but I don't say that your Lordship can't do that, your Honour can't do that of your own motion, but I say that you raise it as a point of clarification, not as a direction or an order necessarily. And but seeing as my friend has now made an application, we have to deal with it, and those are my submissions, unless I can assist you.
Mr. Bigford-Smith?
Thus far we have avoided it. We disagreed about the pleadings, Mr. Setting. I'm afraid I must disagree with this. First of all, I do not accept the representation of the law of England and Wales that has been made. The correct rule, this court is not an employment tribunal. Employment tribunals would be equivalent to the SCT, where there are completely different rules and practices. As your Honour will be aware, in the SCT here, legal representation isn't even permitted. The employment tribunals in England and Wales are not bound by the civil procedure rules. They are not bound by the strict rules of evidence. Their self-contained rules are completely irrelevant in my submission to the position before this court. The analogy, if and insofar as there is one, is CPR 32.2.1, which states that the general rule is that any fact which needs to be proved by the evidence of witnesses is to be proved at trial by their oral evidence. And what the White Book, which is the UK equivalent of the Blue Book, says about this.
I'm very familiar with the White Book.
I hope I wonder if Your Honour has my habit of keeping old versions of the White Book. But anyway, what's said in the White Book at 32.1.4.3 is that in civil trials, the witnesses as to fact of both parties are normally allowed to remain in court throughout the hearing. But for the purpose of preventing the evidence of such witnesses from being influenced by what they have heard and seen of witnesses called to testify before them, the judge has power on his or her own initiative or on the application of a party to exclude them from the hearing until they are called, and also to require them to remain in court after they have testified. No rule of law requires that in a trial witnesses must remain out of court until their turn to give testimony arises. It's purely a matter within the discretion of the court. There is a position whereby in the UK, I believe it's a family law case, Luckwell and Limata, whether that's specific to family law, I doubt, as it's cited in the White Book. It was stated that a judge should only exclude witnesses if satisfied on the facts and in the circumstances of the particular submission that it would, for good reasons, be an appropriate step to take. There's also a broker case where this arose. That's a team. In my submission, this is a classic case where there should be an order for witnesses not to be in court while they are giving testimony. Your Lordship is familiar with the allegations, and that is what I would say.
My learned friend's submission just now is entirely consistent with what I've just said.
Yes, all right.
We don't disagree on the law. We don't disagree on the procedure. I don't see anything that he said which contradicts what I've submitted to you, other than he's made reference to the CPR provision.
Right, well, thank you for that, and I agree that the submissions I've heard are, in a sense, concurrent in that they both submit, both parties contend that I have a discretion to make an order to exclude the defendant's witnesses until such time as they've given their evidence, and that it is a discretion to be exercised in the particular circumstances of the case. The application that's now made for such an order is made prior to any of the defendant's witnesses giving evidence, and is therefore, in my view, timely, although I accept that it would be usual practice for such an order to be sought at the commencement of a trial. In this case, no harm is done because no objection is taken to the presence of the defendant's witnesses during the cross-examination of the claimant. So the question that I must determine is whether the circumstances of this case justify the making of an order to the effect that each of the defendant's witnesses shall remain out of court and shall not be exposed to any of the testimony given by any of the other defendant's witnesses before giving their own testimony. The circumstances of this case are on the record and needn't be paraphrased by me at this stage, other than to say that a significant component of the case is an allegation that many officers of the defendant colluded and collaborated with each other in order to cause disadvantage to the claimant for reasons that were motivated by one or other of the prohibited characteristics, and in particular the allegation of discrimination on the basis of race/nationality. The factual issues pertinent to that claim turn very much upon issues of credibility, and extensive periods have been set aside for the cross-examination of all the witnesses in this case because of that consideration, that they turn critically upon credibility. Given that the nature of the case is one of collusion between persons who include many, and indeed most of the witnesses who will be giving evidence on behalf of the bank, this seems to me to be preeminently a case in which such an order should be made in the interests of justice, in order that I can assess the credibility of the witnesses untainted by anything that they may have heard as a result of being exposed to the testimony of witnesses who've given evidence prior to them. So for those reasons, there will be an order that the defendant's witnesses are to remain out of court until giving their evidence, and are not to be given any information in relation to the testimony of other defendant's witnesses before giving their evidence. After they've given their evidence, of course, they are free to remain in court, but there's no obligation on them to do so. So I hope that makes the position clear, Mr. Setti.
There is a point of clarity further to that, Your Honour, and I'm grateful for that direction. That clarifies the situation. Say for one point, that they can remain in court presently and observe proceedings if they're doing so remotely until
you go into evidence. Until you go into evidence, yes. There's no objection to that. So there's no objection, is there, Mr. Biggs?
No, there are 2 points. First, there is no objection. Second, on formal points, an order will, I'm sure, be drawn up today to reflect this. Just a point I will clarify now. This is obviously being streamed on YouTube, so the order should encompass that.
Yes. And so the order then will be, obviously, that none of the defendant's witnesses are to have any access to any information relating to the testimony of witnesses who give evidence prior to them, and that includes accessing information through publicly available means such as YouTube. But Mr. Setti, confirming there is no objection to your witnesses watching these proceedings until such time as you go into evidence.
I'm very grateful.
Thank you.
Thank you, Your Honour. Mr. Mahmood. There came a point in time when formal complaints were made about you, and that you raised a few moments ago, and they were looked into and investigated by Aziza Dada, Employee Relations Manager based in the UAE. Now, we can deal with this hopefully relatively quickly. On the 16th of June of 2019, we know that she sent her report to your manager, and that's at page 2478.
Sorry, what was that page number again?
2478.
Thank you.
And it's a timeous subject that we're addressing at this stage in your testimony, Mr. Mahmood, given the nature of the application that was made. Now, you see at page 2478, don't you, Ms. Dada, sending a copy of a report to Rehan Sheikh and Adam Long, and to Mirna Al-Najjar, and to Diana Tabara, yes?
And Huda Al-Mazin.
That's right, and Huda Al-Nazam.
Yes, I see it.
Now, Mr. Long will give evidence to say that this was the first time that he had any knowledge of these complaints that had been made against you. Okay? Do you have any evidenced reason to dispute that?
I wasn't aware of these complaints at the time.
That's not answering my question. Again, please.
Can I finish? I wasn't aware of the complaints at the time, and I was not aware of Mr. Adam Long's involvement in them or his response to them.
You still haven't answered the question. I'll only ask it one more time, because I can't keep doing this.
Okay.
You'll be here for the rest of the week, and I'm sure you don't want that. Let me ask you again. Focus on the question, the words I'm using. You have no evidenced reason or basis to dispute Mr. Long's evidence that this was the first time he had any knowledge of the complaints against you. What's your answer?
I'm not aware of these issues as they occurred at the time.
Still doesn't answer the question. Do you understand the question? What do you understand by my question?
You asked me if I have any evidence.
Can you repeat the question back to me? Just
you
repeat
asked-
my question back. Would you repeat my question back to me, please? Just so I understand you, do you understand it correctly?
You asked me if I have any evidence. Yeah.
Do you have any evidenced basis to gainsay or to suggest that when Mr. Long says to this court, this was the first time he learnt of the complaints against you, that he is wrong in that evidence? Do you have any basis to suggest that he is wrong when he says that?
I can't say because he may have been one of the people that made an anonymous complaint. There were 2 anonymous complaints. I have no
Is the
idea.
answer no? Or is the answer yes?
If you want my answer to be no, Mr. Sessi, I'll give you a no.
It's a no, is it?
If you want my answer to be no, I will
Well,
give you
Mr. Mohamed, that's not particularly helpful to me.
Sorry. Okay, I'll
Just
say
do no.
no.
your best to answer the question,
All right.
rather
Let
than
me say
arguing
no.
with counsel.
Thank you. Now, the first Speak Up Against You, we know, was submitted by email under the pseudonym name of Jack James on the 28th of January 2019. Just for the court's reference, that's at page 1900. You might want to just remind yourself of that one. The second one was submitted on the 30th of January 2019, anonymously. That's at page 1904. A third complaint that Ms. Dada looked into was from Fatima Youssef, Manager Risk Management and Governance, SADC, and that was made, as you understand from Ms. Dada's report, orally to HR. And fourthly, Geeta Nilakantan, Manager Risk Management and Governance, SADC, so in the same or similar position to Ms. Youssef in terms of job title, and that was submitted in person also to HR. And when I say to HR, I mean to Diana Tabara, on the 3rd of February 2019. So you understand now, don't you, that those are the 4 complaints that were determined by Aziza Dada,
I do.
or investigated. And she produced this report, which we then see at 2478, where she sets out the background, the allegations, other findings and recommendations. So the allegations that she sets out, we can see them on item numbered 1 through to 7 on pages 2479 to 2480. Yes? Are you looking at that?
2480, yes.
2479 to 2480.
That's correct.
We can read what they say. Her conclusion was that, or conclusions in relation to each allegation, was that those 7 allegations were not upheld. And the report also concluded that, quote, this is at page 2480, there appears to be an unhealthy relationship between the COO of Islamic Banking, SA, and the head of compliance of Islamic Banking, SM. You see that?
I do.
Under the heading of other findings. Now we know that on the 16th of June your manager responded to Ms. Dada, highlighting his surprise with receipt of the report, particularly given that he wasn't, he says, even aware the investigation was taking place, and also the fact that, given that one of his subordinates was being investigated, he was not interviewed as part of it. You see that at page 2478. So let me give you the page reference for that. 2477. You go to 2477, please, at the bottom of the page. And Mr. Mahmood, one of the reasons why I'm taking to communications in this case that you will not have necessarily have been privy to at the time but you've now seen them post-disclosure in this matter, and I want to understand whether your claim and your appreciation of your own claim has in any way been reflected upon by greater knowledge now of internal communications, and whether that means you are tailoring or adapting in any way your original claim, or whether your original claim still is being fully maintained by you. Okay?
Fully maintained, yes.
Sorry?
It is being fully maintained.
It's not affected at all, you're saying, by any of this disclosure.
To the effect that I'm becoming of more individuals that were involved. But yeah, in terms of my generic claim about discrimination from GIB and from compliance management, that hasn't changed the fundamental underlying basis.
Yes, okay. Well, your pleaded claim, you say, doesn't change. He says, I'm a bit surprised to receive a report with final conclusions regarding an investigation of one of my direct reports when I do not believe I was even aware of the investigation in the first place, nor was I interviewed as part of the investigation. Now, he discussed Ms. Studder's report with her, he says, on the 17th of June. And on the 18th of June, he sent Ms. Studder an email. We see that at page 1174. I'll ask you to jump to that, please. Sorry, I think that page number is wrong. It's 2484. Could you go to 2484? On 2484, do you see an email of the 18th of June from your line manager to Ms. Studder? Bottom of the page. No?
16th of June? I just want to make sure
that I'm giving you the right page reference.
It's the same email we looked at earlier, I think. That's
2483. Yeah. 2483, please. Could I ask you to look at that statement? Have you read it?
I'm reading it. I've read it.
Thank you. There are 3 numbered paragraphs there, helpfully, and in the first, he's saying to Ms. Studder, isn't he, that it appeared to him that 2 of the complainants, Ms. Yusuf and Ms. Nilla-Canton, had not been interviewed, and he was therefore concerned that the report was accepting all other witnesses' views over the 2 complainants without having further discussions with them. you see that query that he was raising?
I see that he questioned whether they've been interviewed.
Yes. Now, your line manager raising this concern was in your interests, wasn't it? He was concerned that there, on an issue of what he perceived to be fairness, he wanted to make sure that everyone that needed to be interviewed had been interviewed. Correct?
Yes, he was asking if everyone had been interviewed.
And then in number 2, he wanted to clarify that Mr. Akbar's statement that the 365 feedback provided by you was not true should not be taken as fact. Do you see that?
I do.
He says that what we see there is that he highlighted that whilst, and you see this towards the, in the middle of that paragraph, the sentence beginning, although the directness. He says, although the directness and the one-sided negative nature of the feedback was not the right way to provide the feedback, which I addressed through my own P3 rating and compensation decisions for SM for 2018, my view, as discussed in many meetings with stakeholders in HR, compliance and IB, is that this feedback on SA contained tangible performance issues that needed to be addressed from a performance P3 perspective. So he's saying there that there is some substance. He's supporting, in a sense, an aspect of your position where he's saying there is substance to performance issues relating to Mr. Akbar. Yes?
He is.
And then in item 3, he observes that it was recommended that the line managers address the apparently unhealthy relationship between Mr. Akbar and yourself. And he pointed out here that he had been trying his best since August, September 2018 to make the dynamic work. Yes? Do you see that?
Frankly, I believe we're trying our best as LM since August, September 2019, and truly feel that we're seeing improvements. Okay.
You see that, I mean, it's almost the entire section 3 there, which we've all read now. But he points out, doesn't he, that he's been trying his best since August, September 2018 to make the dynamic between the two of you work. And that whilst he thought there had been recent improvements, he was unclear what else he could do. And he therefore requested a meeting between himself, Mr. Sheikh, and HR to discuss. So that's set out in paragraph 3, isn't it?
It is.
Thank you. Now, your manager then, at this stage, forwarded his feedback to Ms. Dudder, that we see, to Mr. de Groot and Mr. O'Donnell. So Mr. O'Donnell is your line manager's manager, and Mr. de Groot and Mr. O'Donnell's line manager, by way of update. And he did that, we see at page 2482.
Seti, can I ask you something, please?
I'm afraid not.
Okay.
You answer questions.
Understood.
I'm the one who asks them. So, what we have here is Mr. Long now communicating with Mr. O'Donnell and Mr. de Groot. The message on the 18th of June is timed at 6:26 in the morning. And he confirms in this one, he expresses his frustration that he had not been interviewed as part of the investigation, given that particularly the report referred to P3 decisions and actions that he had taken in relation to the claimant. So he wasn't aware of it and he wasn't interviewed by it. And he's expressing his surprise to his line managers. Again, you have no reason to dispute the genuineness of his position as stated here, do you?
Actually, I'm trying to understand his statement about, I will call Simon from I3 today to inform him and let him know he not. Just curious about that.
Yes, your curiosities can remain with
No,
you.
but
Can you just
then-
answer my question,
Yeah,
please?
it does raise a question about his motivation, because that's a speak up that was supposed to be confidential, and he's discussing with Mr. de Groot and Mr.
Well,
O'Donnell. So,
Mr. Mahmood, this is not the opportunity for you to make arguments. This
Sorry.
is your role, as I've told you before, is to answer questions. Now listen to the question and answer the question.
sorry.
You have no reason to dispute that when Mr. Long is telling his line manager and his line manager's line manager that he's taken by surprise by the data investigation report, you have no reason to dispute the genuineness of his position as stated in this email, do you?
In relation to the surprise, yes, but in relation to motivation, no.
Sorry, say that again?
In relation to his surprise, yes, I believe he was surprised. You use the
And
word.
what was the latter part of your answer?
In relation to his motivations around the speak up, just a bit concerned. Maybe it's irrelevant. Sorry,
Well, we weren't asked about his motivation.
Yeah, sorry.
Your Honour, I say this, it's not really an objection, it's just to assist. I think one of the witness needs to answer the questions, we all need to get done. One of the concerns I have, and it was something I was going to raise at the end of evidence, is about these questions of you have no evidence or you have no reason to. It seems to me that those questions, insofar, those are absolutely valid questions insofar as your testimony, your witness testimony, you do not have any reasons to do that. I think the problem, I have no idea about this, but the problem I think is that Mr. Mahmood may be being drawn into a debate about is there some other document in the bundle which I should be referring to, and that is not what I understand my learned friend to be asking, and in any event, that it should just be a question about what his testimony is.
Mr. Setti?
I'm only asking this witness as to what evidence he can directly give this court from his own knowledge as to whether he has any factual basis to gainsay something that we see on paper here.
Thank you. That's
Very straightforward.
Now, you understand that, Mr. Mahmood. When you're being asked, do you have any reason to, or is there any evidence to cause you, you're being asked to state what you know, not to trawl through 8,000 pages of data.
That's really helpful, because my concern was I'm not familiar with everything in that bundle,
Yes.
and I want something to be relied on, so you didn't mention
Yeah,
that.
thank you.
Yeah, it's your knowledge and your knowledge alone that I'm concerned with now.
Ceci, I'm sorry, I'll not try and. So on that understanding, I'll base it on my mental knowledge, what's in my brain, rather than on papers. As far as I know, where I do know papers, I'll mention those. That
Feel
helps.
free. Now, do you need me to ask that question again, or can we move on?
No, I agree in terms of Mr. Long was genuinely surprised.
But do you also see that in these communications of which you were not aware at the time, your line manager is actually making observations which are in your interests? You know, he's raising, for example, that in his view there are some real concerns about Mr. Akbar, for example. Do you see that is going on
I do,
in the background here?
I do.
Now, Mr. de Groot responded asking Mr. Long if the FCC I3 were aware of the data investigation. We see that at 2482 in the middle of the page. In fact, Mr. de Groot's response is, thanks Adam, very odd and wrong from HR to inform you after the fact, and happy to follow up with Myrna if helps. I noted your very good spot-on comments below. And then he goes on to deal with R3. Is I3 informed of this? Do you see that?
I see it.
We'll hear from Mr. de Groot, but it appears that Mr. Groot was also taken by surprise by the data report process. Yes? That Mr. Long had not been involved he also says in this email, this is Mr. de Groot, I don't know what their own investigation really relates to, since my own interview is next week. So here he's referring, I think, to the I3 interview, the I3 Barroso. And then he goes on to say, and I appreciate you are not allowed to let us know more, so please don't, but we should make sure all dots are connected, including the BMA team. Do you want me to follow up with them directly? So there's a conspicuously careful approach here, isn't it? Isn't there, to make sure that people are not informed of matters of which they should not, or matters which should be remain confidential. You can see that in this communication between your senior managers, can't you?
I can in this communication.
I see. Now, Mr. Long responded to Mr. de Groot, confirming that he would notify Mr. Bucket about the investigation and that he should contact Ms. Dada. You see that at 2482 at the top.
I did.
And Mr. Long says he felt it was important that the Project Barroso team were kept abreast of all matters which could be relevant to their investigation. And then on the 18th of June, Ms. Dada addressed each of the points that Mr. Long had raised with her at page 2489. Could you go to that? And I believe what we see here in the red are the responses that Ms. Dada provided to Mr. Long's black inked queries. Do you see that?
I see.
Now, she confirmed to your manager that she would arrange a meeting with Mr. Long, Mr. Sheikh, Mr. Barra and Ms. Al-Najjar to discuss further, didn't she?
She did.
And in early July, Mr. Long tells us there was a meeting between him, Mr. Sheikh and Mr. Barra and Ms. Al-Najjar, where your line manager was asking them for some guidance on how to proceed with you. So your manager was seeking advice. And he says the feedback from Najjar was that you could be placed on a performance improvement plan, or there could be a restructuring of your role. And he says that given none of the allegations against you had been upheld in the Dada report, he didn't think a performance improvement plan was an appropriate measure. But then he said that he would reflect, and did reflect on their suggestion, this is HR's suggestion, that there might be a restructuring. Again, just while we're looking at these matters, in your knowledge, you have no reason to dispute.
Ms. Sethi, are you
That
talking
you-
about? Sorry, are you talking about page 2489?
I'm telling you what your line manager's position is on this at this point in time. And what I'm asking you is, within your knowledge, you have no reason to dispute that, do you? That at that time, Mr. Long received that feedback from Mr. Barra and Ms. Al-Najjar.
I just can't see that feedback. I can't see what you're...
It's not in that document.
Oh, okay.
It's following that document. There was a meeting. I don't believe we have a note of the meeting, if that's what you're referring to. There's no minute. But that's Mr. Long's position, that he was given such advice. Now, your position on this, as I understand it, is you can't say either way whether that's true or not.
Wasn't even aware a meeting took place.
Indeed. We need to deal with this because, of course, the suggestion is that there's some other concerted collusion going on here behind the scenes. Now, I think the next matter to take you to chronology is everything here, is the draft BMA report. On the 29th of July 2019, a meeting takes place with the head of BMA, Crispian Cuss, to discuss the BMA team's initial assessment of GIB. And we know that a meeting invite was sent out. That's at page 29-28. You are sent this email, aren't you?
Yes.
So you, together with Mr. Sheikh, Mr. Akbar, Mr. Hilal, Mr. Ali, Mr. Pasha, and Mr. Vaselli, and your line manager, Mr. Long, were all invited to discuss the draft BMA report.
I can't see Alessandro's name, Mr. Vaselli's name either. Don't know if he was at the meeting. I don't think he was. If he's not on that meeting invite.
Okay, I'll check that point in relation to Mr. Vaselli, but the others are there, aren't they?
Yes, they are.
Now, we know that as part of its assessment of the theme of the Sharia non-compliance, or Sharia reporting line, the draft BMA report identified the Sharia reporting line as a conflict of interest.
The draft did, yes.
And we know, if we look at... oh yes, the report, the draft report, Judge, was attached to this email, so it follows helpfully on this occasion. 2930. If your Honour wishes to rotate the document clockwise, if you're using the same software we are,
I've got it on PDF, so I'm not sure that I can. But anyway,
it may avoid cranking one's neck. But
yeah.
what it says in the middle column there, you have a residual risk and then an observation. Do you see that?
Yes, I do.
Do you see that, Mr. Mahmood?
I do.
And under risk, it's got in the middle row, there are three rows, three substantive rows, and the middle row says that the residual risk is 2B. I'll come back onto that in a minute. But next to that, it says as follows: conflict of interest. The head of Sharia department currently reports into SADC CEO rather than sitting independently of the business. Responsibilities including advising the independent Sharia board and at times acting with their delegated authority. This is unsurprising due to their numerous commitments to other financial institutions. In addition, their performance objective also includes supporting the business deliver a revenue target. It is understood that Dubai FSA approved this reporting line in 2010. And as I say, a 2B residual risk assessment was made. This draft BMA report, did not include an action point, did it, in relation to this matter?
The report did not. I can't see an action point in the report.
Exactly. And the intention was that action points would be agreed with the GIB management team.
I believe that's.
Hence, this was a discussion to discuss the draft BMA report.
It was a discussion to discuss.
Yeah. And the point was that you would agree action points as a result, wouldn't you? That's your understanding, isn't it?
It was, from my memory, it was a discussion to discuss the draft BMA report, and my understanding was that whether the Islamic banking team had any objections or comments on the report itself. There may have been an additional piece around action points.
Indeed. The bank implements this group risk assessment matrix via this alphanumeric score, doesn't it? With the highest rating, as you understood it, being a 5E, and the lowest risk rating being a 1A. Yeah, so 1A is low risk, 5E is highest risk level. And the BMA team's initial assessment assigned a gross risk of 3 and a residual risk of 2B to the overall theme of Sharia non-compliance. That's right, isn't it?
That's what it says, yes.
So the Sharia non-compliance, which includes a Sharia reporting issue, is given a residual risk rating of 2B. And the point that this indicates, doesn't it, is that at least from BMA's point of view, which is quite an important point of view in these matters, they came to the conclusion that the Sharia reporting line issue was a medium to low risk matter. Yes?
That was their finding.
And that is consistent, isn't it, Mr. Mahmood, with Mr. Long's position throughout and others that the Sharia reporting line was not a priority matter?
That's not consistent with the conversations I had with Mr. Long.
Is it at least consistent, we disagree with that, but is it at least consistent with the Sharia reporting line not being a priority matter?
It was for me.
No, please answer the question.
Sorry.
One last time. Let's try again.
Okay.
But I won't ask for a fourth time. This is not a
Apologies.
pantomime.
Please let me.
A score of 2B by the BMA team that assesses risk is consistent with the Sharia reporting line issue not being a priority matter.
In their view, I said in their view that's their finding, so yes.
Yes, thank you. And we know that's maintained, Judge, because I gave the court the reference of page 3611 yesterday, where you see the final report, and that 2B low risk rating is maintained.
Thank you.
And the final report is at page 3611, and the particular page where you see this is 3614. So just as a, it's perhaps not even a question, but perhaps impermissible, but as an observation at this stage, Mr. Mahmood, would you agree that you considered this a very serious matter? Others did not consider it, others in management, in compliance management and GIB management, did not consider it as pressing a matter as you did. And subsequently, BMA have come to closely assess it, come to their conclusion that it's a low risk matter. And we know that eventually the reporting line was changed. Do you accept that that's, as a global summary of this Sharia reporting line issue, what occurred?
Apart from Mr. de Groot and Mr. Long, who I did speak to about this particular issue, and those conversations and what you're saying, I
Yes.
would disagree.
But you agree with that summary I've just given, which is that you consider it, I'm simplifying, I admit I'm simplifying, but just for the sake of understanding where we are in this process, you considered the reporting line issue to be a very, very important, pressing, acute matter. It seems that everybody else in compliance and GIB did not. BMA look at it, they assess it as low risk, and as it happens, eventually it does get changed. So you do get, at the end of the story, a change to the reporting line that you were advocating for. Yes?
Yeah, I agree with that. Apart
Good. You agree with all of that what I've said so
no,
far?
I don't.
No?
As I said before, sir, that's a fair summary, but when I spoke to Mr. Long and Mr. Groot,
Yes.
I said there's a priority. I didn't get any indication from them that it wasn't.
Okay, that's fine. Perhaps there's a danger in any counsel in my position seeking to oversimplify something which has a lot of factual material behind it. Let's move on. Now, diversity of the GIB team was discussed during this meeting, wasn't it?
During this meeting around the BMA?
Yes. Draft BMA.
Honestly, I can't recall if diversity was discussed. I don't think
Okay.
it was.
You don't think it was? That's helpful. Thank you. And that's consistent with Mr. Long's view. Let's then move on to the atmosphere at this particular meeting. Would you agree that the atmosphere was positive?
This particular meeting?
Yes.
Yes, it was fine. It was accepted by the Islamic banking team.
Yeah. Good. So that's not an issue. You later that day sent an email to Mr. Cuss, the head of the BMA, attaching a table which you said may assist in the drafting of the finding relating to diversity and inclusion raised in the BMA, and that's at 2941. So it appears that you raised the matter after the meeting. You stated that you disagreed with the view expressed on the call that the talent pool for Islamic banking was largely confined to Pakistan and listed the nationalities of the members of the Islamic banking team from your previous employer, HSBC. Do you see that at 2941?
I see it.
And on the 5th of August, you forwarded to your line manager the meeting appointment that you had been sent by Mr. Sheikh. That's at 2975. We know that the other invitees to the meeting were Mr. Akbar, Mr. Vaselli and Mr. Pasha, and it was to discuss again the draft BMA report. We know that Mr. Long didn't actually attend this meeting on the 5th of August because although he'd received the appointment email from you, he says he received it 90 minutes after the meeting started, so that's why he didn't attend. Again, just on that point, so you've got no reason to
No reason.
to suggest otherwise.
No.
And that's at 2975. Then on the 6th of August at 8:33 in the morning, you sent Mr. Long an email summarising what you said had been discussed about the issue of the Sharia reporting line on the call the previous day on the 5th of August. So it's at page 2978, please. Your email to your manager here, early the next morning after the meeting of the 5th, did not refer to any alleged comment made by Mr. Akbar to Mr. Vaselli, did it?
No, it did not.
Now, on receiving your email, your line manager says that his view was that this was simply a continuation of the disagreement between GIB and you about the Sharia reporting line. In other words, a continuation of the same issue that had been ongoing since 2017. He also says that he was mindful of the action plan in the draft BMA report requiring the Sharia reporting line to be changed by the 31st of December 2019, which he intended to act upon and deal with. Now, just at this juncture, you have no reason yourself, within your own knowledge, to dispute that your line manager was fully intending to action the BMA recommendation of changing the reporting line by the 31st of December 2019.
The statement you just read out, I do find it inconsistent with what we just looked at earlier because you said there was no action plan in the BMA draft report, but you're now saying Mr. Long says that there was an action plan in the draft report. But that's the only thing I dispute. But
I see. Yeah, but don't worry about that tonight. Your line manager fully intended, he says, to implement the ultimate recommendation to change the reporting line at this stage.
that I have no disputes about.
Exactly. Thank you. Mr. Long will say that shortly after he received your email, he was telephoned by Mr. Sheikh, who was very upset with the way in which you had behaved during the call on the 5th of August, the previous day, and that Mr. Sheikh had said that you had been disruptive and had made inappropriate comments. Mr. Long says he was frustrated at having to deal with another disagreement between you and GIB, and he told Mr. Sheikh that he had been assessing the compliance needs of GIB, and that he was having discussions in compliance about reshaping GIB compliance as part of the project ICEE regional reorganisation. Now, you weren't obviously privy to this conversation at this time. But again, now, today, you have no reason to dispute that, do you, that you had that conversation with Mr. Sheikh?
I honestly can't say yes or no.
Within your, no, that's a perfectly understandable answer. Thank you. And I only have to deal with it in this way. Normally I wouldn't, but because of the nature of the claim that you bring. Now, we know that Mr. Sheikh then sends an email to Mr. Long on the 15th of August. It's at page 3131. And let's just see what it says. This is further to our recent discussion on captions subject. I would like to reiterate that it is becoming increasingly difficult for me to conduct regular business with the attitude that Shiraz continues to adopt. His approach is becoming disruptive by the day, and I'm really struggling to run a productive unit under these ongoing distractions. Since having consulted HR and compliance seniors on various occasions in the past, I've tried to make things work as much as I could. More recently, we worked extensively with the whole team and agreed on an engagement model. That's a reference to the engagement plan we were discussing yesterday afternoon, isn't it? To ensure there is no ambiguity around the required and expected working relationship. Given my recent experience with Shiraz, I don't think it is being approached in the right spirit. Given the background, as well as the most recent incident of which I advised you, and where his unwarranted comments continue to prevail, my fear is that this may unfortunately lead to an extremely unpleasant incident. May I therefore request your presence in Sadiq top team key meetings to ensure that there is a balanced compliance view of the business conducted and we are able to avoid any potential disruption to the business. If you are okay, I will send you the requisite invites. And just for completeness, as agreed, I would not like to engage HR at this stage, since this will again take valuable time away for another investigation, something which we have already gone through. I would nevertheless request that you advise my reservations to the officials of the team who have recently conducted the detailed review on similar matters. Now, Mr. Long says that that email from Mr. Sheikh reflected the discussion he had had with Mr. Sheikh. And on the 18th of August 2019, he then responded to Mr. Sheikh by email. It's saying that he was happy to attend, as we see at the top of the page, happy to attend all senior Sadiq meetings. Bear with me a moment. And he says also here, further as discussed previously, we will be reshaping the role as part of our regional level ICEE exercise in September. And then on the 2nd of September 2019, we have an email at page 3133. Can I ask you to go to that?
Page number again?
3133.
Thank you.
Where your line manager is asking Mr. Sheikh to forward him invites for any meetings that Mr. Sheikh wanted Mr. Long to attend, and Mr. Long also suggested to Mr. Sheikh that he provide his comments about your behaviour directly to the HR team, which conducted the investigation into the speak-ups. Those are the 4 complaints that were brought against you. The Darla matter, that is. Now, looking at this internal communications between Mr. Mr. Long and Mr. Sheikh, you don't for a moment suggest that any of these emails, or indeed any other emails that we see in the bundle, are fabricated? Yes, made up. They don't mean what they say. They were genuine emails sent at the time, as we see them. You don't have any reason to suggest otherwise, do you?
Based on what I'm reading, I have no reason to suggest.
Okay. Thank you. Let's then move on slightly in the story then to deal with another matter that's then going on at this time. This is about your move to the compliance floor. Okay? As I understand it, GIB sits on the 3rd floor of this building. Compliance sits on the 2nd floor of the building. Is that right?
It's been a few years, I think that's right. I can't definitively say, and I'm not being difficult, I just genuinely
No,
can't.
that's fine. That's fine. Well, that'll be our evidence, and that's fine. Now, as you understood at the time, the bank operated and operates a flexi desk arrangement, doesn't it?
Yes, it does.
And employees don't have their own set desk, which they use every day as a result. Yes?
That's not accurate.
Okay. Now, instead, if an employee wishes to work in the office, they can use whatever desk is available on the floor designated for their business unit or function, can't they?
No, not where people are using desks on a daily basis and have allocated them to themselves.
Well, if someone is in the habit of going to the same desk every day, you may come to learn that fact and try and avoid it out of a courtesy to them. But as a matter of formality, it is a flexi-desk arrangement. It's first come, first served, and you go and sit wherever you can.
No, sir. It varies by business to business. So, for example, in FM, that just wouldn't be possible. In FM, there were dedicated desks for the dealing teams, etc., and that was for compliance reasons. In GIB, when we relocated, we were on one floor, we relocated to another floor, and as part of that relocation exercise, everyone chose a desk and was allocated a desk. So whilst the bank operates a flexi-desk policy, that was not the practice in the areas that I worked in.
Well, we disagree. The compliance function sits on a different floor to the GIB team. You accept that? And the claim, as a matter of your own practice, had mostly used desks on the same floor as the GIB team, hadn't you?
No, I was an allocated resource to GIB, and I sat on the GIB floor. It wasn't mostly, it was...
But whilst you mostly use desks on the GIB floor, you also would use desks on the compliance floor, wouldn't you, from time to time?
I never did that until I was forced to.
Now, your line manager would say that before law, you did, on occasion, use compliance desks. From time to time is the phrase I'd use, albeit that you normally were on the GIB floor. Do you accept that?
I totally disagree with that.
So you say you never would use a desk on the compliance floor?
I never did
with
it
the rest of your compliance team?
I never did it while I was in financial markets. I never did it while I was in Islamic banking.
Now, on the 6th of September, your line manager received an email from Diana Tabara, the head of employee relations in the UAE. Let's have a look at that email. It's at page 3247. It starts at the bottom of the previous page, in fact, but the substantive part is at the top of 3247. Now, she says, I am writing in reference to a strictly confidential review not against Shiraz, to suggest that Shiraz works temporary on the compliance floor, considering the stressful environment on the Islamic banking floor. I am concerned about his well-being, as well as to reduce unnecessary noise. please let me know your view. Now, just pausing there for a moment. This email tends to suggest that the idea of you moving away from the GIB floor originated from Ms. Tabara. Would you agree?
It was, as far as it was Mr. Barra's idea.
Thank you. And she invites your line manager's view on the subject. Now, Mr. Long will say to this court that he assumed at this point, when he received this email, that you had actually requested the move yourself. And given the ongoing difficulties in the relationship between you and GIB, he felt that Mr. Barra's suggestion was a sensible one. And particularly given her reference to being concerned about your well-being. Now, that's not inviting an answer to any question at that point. I'm just pointing that out for context. He will say that he did not consider it to be a particularly big deal in terms of day-to-day working arrangements, because it wasn't common for members of the compliance team to sit with a compliance team away from their respective business unit. Do you agree?
Depends on the business. So for capital markets, financial markets, Islamic banking, the compliance functions sat on the floor. For transaction banking and corporate banking, those two individuals sat on the compliance floor. In terms of the allocated spaces, the gentleman who looked after capital markets compliance and financial markets compliance and myself never moved from our desk to sit on the compliance floor. We were all dedicated to those floors.
At 3246, if you look towards the bottom of the page, the bottom half, at 1046, Mr. Long responds to Ms. Tabara, I am fine with Shiraz working on the compliance floor. If he had asked me himself about this directly, I would have immediately said yes. To which Mr. Barra then responds, we see further up the page, for the avoidance of doubt, Shiraz hasn't asked to work on a different floor. It is my suggestion, since I believe this would be the best arrangement for the time being until the review is closed. I am concerned about his well-being, as well as to avoid unnecessary noise or disruptive / stressful environment. Please let me know if you prefer to speak to him, or should I? And your line manager at this, in response, suggests that both he and Mr. Barra meet with you. Yeah? See at the top of the page, 3246. Yeah, 3246. But it starts again at the bottom of the previous page. At the top of 3246, perhaps we can meet with him together. I would normally be happy to do it myself, but I would not be able to answer any questions he may have on the background to this proposal, or to the proposal. You see?
I do.
Now, on the 8th of September, you had a telephone conversation, didn't you, with the line manager and Ms. Tabara?
So Mr. Long and myself were in a meeting room. Mr. Barra was on the phone.
I see. Thank you for that clarification. In that telephone conversation between you and your manager, Mr. Barra, Mr. Barra explained to you, didn't she, the proposal that going forward you would use a desk on the compliance floor instead of with the GIB team?
She did.
And you said that you were fine, that was fine?
I totally reject that assertion.
And you also said that you did not think a move was necessary.
I said, yes, it was wholly unnecessary.
you suggested splitting your time between the GIB floor and the compliance floor, didn't you?
No, I didn't.
However, Mr. Barra was insistent that you should sit with the compliance team full time.
She was.
And your line manager was supportive of her position in light of her concerns about your welfare, your well-being.
He was passive during the call.
All right. He was passive during the call, but do you accept that he was genuinely concerned for the well-being of you that she had identified?
No, because after the call we had a conversation and he knew there was no issue around my well-being.
Well, shortly after the call, what we know happened is that on the 8th of September, your manager sent an email to Mr. Sheikh, copying Mr. Barra and copying you in, confirming the move. Let's just look at what that email says. This is shortly after the call. It's at page 3256. It says, at my request, starting tomorrow, Shiraz will be working from the second floor of the IFC along with the other members of our CFCC advisory team. He will still be attending any one-to-ones in your Islamic banking area on 3F, that's presumably third floor, and when it makes sense to do so, remaining there between such meetings. Let me know if you want to discuss. Okay? And you're copied in on that one, aren't you? Does my learning friend have a submission?
Just page reference, sorry.
3256.
Sorry.
That's right. Now, it's apparent, isn't it, here, from the evidence that I've taken you to, that although Mr. Barra had initially recommended that you sit with the compliance team, ultimately it was Mr. Long's decision
No.
that you should sit with the compliance team. You disagree with that?
Yes, I do.
Okay, so firstly, whose decision do you say it was?
It was Mr. Barra's, and as I said, we had a conversation. Okay, sorry.
That's fine. You say I'm wrong when I say it's Mr. Long's. You say it's Mr. Barra's decision. That's fine. Let's just leave that there, but as an item. You have no knowledge, do you, yourself, that anyone asked Mr. Barra or told her to engineer your move from one floor to another, do you?
I have no knowledge.
Right. Okay, so we'll hear from Mr. Long in relation to that matter. Now, your manager will also say on this point that it was common for compliance colleagues to sit on the compliance floor away from their business unit. Do you accept that?
In relation to myself and the other two individuals I referenced before, no, that was not common.
All right, but generally, do you accept that it was common for compliance colleagues to sit on the compliance floor away from their business unit? Do you accept that as a proposition?
No, I gave you the breakdown of Mr. Long's team and how they were...
No, apart from you, your position, other compliance colleagues of yours commonly would not sit in their business unit, would they? Do you agree? They sat on the compliance floor.
I've given you my answer. I thought it was quite clear.
If you felt you'd give me your answer, I won't press you. Let's move on. Bear with me for 1 moment. Judge, would that be a convenient moment? Certainly going to move on to another topic.
It's all right. Well, given the timing issues we discussed yesterday, I'd be grateful if everybody could limit the break to 10 minutes. And if that means you need to bring coffee back into the room, I've got no objection to anybody bringing coffee into the room. And on timing issues, as I mentioned yesterday, we'll do our best to finish Mr. Long on Friday. But But of course, Mr. Rossetti, at the risk of stating the obvious, to an extent, our capacity to do that is in your hands in terms of how much longer you cross-examine Mr. Mahmood. But we will sit late to the extent necessary to try and achieve that objective. Mr. Pickford.
I'm very grateful for that indulgence.
If it assists, I sent Mr. Setti a brief thing to say I mentioned 2 hours for my re-examination yesterday, particularly in view of a useful clarification we've had. I've agreed to I'm going to be cutting that down.
Good.
I'm aiming to be an hour and a quarter.
Well, let's see if we can finish Mr. Mahmood today and then we'll stay on track. The reason I mention that is that there is another slight problem on Friday, and I don't know if it'll emerge or not, and I can't tell you much about it because there are security implications involved, but there may be some disruption on Friday to our hearing for no more than an hour, more likely half an hour, I think. But I can't tell you when it will. I can't tell you if it'll happen, or when it will happen, or how long it might disrupt us. But I will say that we will do what we need to do to make up any time that we do lose during the course of Friday.
Very grateful.
Yes,
Your Honour.
all right. We'll adjourn for 10 minutes.
Thank you.
it is very impressive, I have to say. It really is.
It looks good when you do the movie controls and have the three judges, the camera angle, it makes it look huge. Yeah.
Sorry, you drink something?
Unfortunately, probably also means that we look a lot better.
Sorry, drink.
Sorry, my request to limit the break to 10 minutes seems to have fallen on deaf ears. I think steps need to be taken to make sure that that break is limited to 10 minutes. Thank you. Mr. Setti.
Your Honour, thank you. We're going to move on now to the disciplinary proceedings that were brought against you and conducted by Mr. Tabara. Now, two incidents were the subject of Mr. Tabara's investigation, weren't they? There were the two incidents which allegedly took place during the call about the draft BMA report on the 5th of August 2019. Yes?
Could you just refresh my memory in terms of the two?
Yeah, she looked into two principal allegations. One was that Mr. Akbar was alleged to have made a discriminatory comment in reference to you, and the second one was that you were alleged to have demonstrated demeaning behaviour and made a disrespectful comment to Mr. Sheikh and Mr. Akbar in the meeting.
In principle, yes. The second.
Yeah, those are the two areas.
The second allegation was wider, but yes, in principle.
And we know, don't we, that we know now, we can see that a report was sent to your line manager at 3371. And at 3373 we can see that the report made certain recommendations. It said, decide on ways of working to address the long-standing conflict and to create synergies between business and support functions. Determine whether there is a requirement to consider changes in the scope of the role or candidate, taking into account the history of the unresolved disputes between Shiraz and the business, and the main reason for the conflict, and the impact on the continuity and productivity of both. Now, Mr. Long, your manager, will give evidence that he did not know about Ms. Tabara's investigation until he received her report at 3371. You have no reason to dispute that, do you? In your knowledge?
I dispute that very wholeheartedly.
Okay. You have no evidence basis for that answer, do you?
I do. My experience and my testimony.
Anything other than that answer you've just given?
I'd have to go through the documents.
I see. But nothing springs to mind when I say his witness evidence that he did not have any knowledge of Mr. Barr's investigation until he received a report.
No, what springs to mind is me going and showing him Appendix A and discussing it with him and talking about conflict of interest with regards to hearing manager and having an extensive discussion about my concern about this investigation. I went and saw my line manager as soon as I found out about disciplinary proceedings.
I think you're thinking of the subsequent disciplinary hearing process, not the disciplinary investigation process by Mr. Barr.
The investigation process.
So you accept that your answer was confused, you were confusing. I'm not at that stage at the moment.
I
I'm dealing with...
I was referring to the hearing rather than the investigation.
Right. That's what we thought you were referring to. It took me by surprise.
Sorry.
So focus on this point.
Yes.
You've got no knowledge of anything which might suggest that Mr. Long is not being truthful when he says he didn't know about the Tabara investigation until he received her report.
I have no knowledge.
Okay. Helpful. Thank you. On the 10th of October, your line manager received another email from Mr. Barra attaching a revised report reflecting additional witness evidence that had been considered. That's at page 3379. Judge, perhaps that email could be read. So, Mr. Barra concluded that the allegation against against Mr. Akbar was inconclusive and therefore not upheld, and that the allegation against you was upheld. Do you see that?
I see that.
And in her recommendations, in terms of the following actions that she suggested, there were 3. Because I think this is the revision to the last report. They maintained the same, that disciplinary management for the claimant, for you, on the basis of the undermining style adopted against senior colleagues. Sorry, we should be looking at 3377, beg your pardon. 3377. You see the 3 recommendations, A, B, C at the bottom of the page. So disciplinary management for the claimant on the basis of the undermining style adopted against senior colleagues. So just pause there for a moment. You accept, don't you, it's Mr. Tabara's decision to recommend disciplinary proceedings.
Was she the author of this report?
Yes.
She read the report. I don't know who influenced it. Decision.
Okay. And then B, she says, decide on ways of working to address the long-standing conflict and to create synergies between business and support functions. And C, determine whether there is a requirement to consider changes in the scope of the role or candidate, taking in account 1, the history of the unresolved dispute between the claimant and the GIB team, 2, main reasons of the conflict, and 3, the impact on continuity and productive of both. Now, on the 17th of October, your line manager received an email from Rula Al-Tamimi, HR business partner, requesting a discussion about the disciplinary process which was to be undertaken for you as a result of Ms. Tabara's recommendation that the matter warranted disciplinary proceedings. It's one of the ones. I'll give you the page reference for that shortly. 3438, please. Could you turn to that?
Sorry, 3439. Straddles the 2.
Right, 3439. Beg your pardon. So, what we see here is an email from HR to your line manager proposing that your line manager chair the disciplinary hearing that was recommended by HR because he's your line manager. You see that?
I see that.
And then he responds at 3392 to that's 23rd October. Yeah, that's the next day. Yeah. So let's just take this in stages. Mr. Long will say in evidence that he was uncomfortable with the prospect of chairing your disciplinary hearing. in the light of the project ICEE reorganisation and the impact that could have on your role, and the fact that if you were to be made, your role was to be made redundant, he might be on an interview panel for you, so he wanted to remain out of it. On the 21st of October, he relayed his concerns to Miss Al-Najjar, who agreed with his position, page 3392. Can I ask you to look at that?
3392.
3392. And I believe this is a reference, so at 3392 he said, could we have a chat about this? I'm not clear how we proceed with this at the same time as we proceed with the ICEE process, and he says he therefore spoke to her about it. And then on the 23rd of October he sent an email to Miss Al-Tamimi, page 3404 please. And in this email, he confirms that he did not think it was appropriate for him to chair your disciplinary hearing, given his involvement in the implementation of Project ICEE. Do you see that?
I do.
What was that page number again? Sorry, Mr.
3404.
Thank you.
On the 29th of, Judge, have you
Yes, I've got it, thank you.
got that page? On the 29th of October, Ms. Tamimi confirms to your line manager that somebody else has been appointed to conduct and chair your disciplinary hearing in the name of Faisal Abu Shah, Chief Risk Officer, MENA, and Chief Country Risk Officer for UAE, and Head of Risk for Islamic Banking. So he wears those three hats, and he's been assigned to hear your disciplinary after Mr. Long turned it down. Ms. Tamimi says to him that she will notify you of the outcome. That's page 3404. Can you look at that?
Where is that, sir?
Top of the page.
I can't see the bit about notifying me about the outcome.
Right, okay, but she did notify you, didn't she?
Yeah, no, she did, but I just can't see the. Sorry.
Okay, on the 12th of November 2019, Ms. Tabara then writes to Mr. Long, referring to the discussion that they had Mr. Long had with Ms. Al-Najjar about the potential impact of Project ICEE on the claimants, on your role. At this stage, your reply is said to be made to Mr. Barra, confirming that yeah, so you get page 3684, I think that's the right page number. Reply to Mr. Barra, confirming that Mr. de Groot, he's saying he had attended a meeting led by Mr. de Groot the previous day about CFCC restructuring at the regional level. That's 3684.
That's Pavneet Bajwa saying they rushed me to assess the role.
Yes. Is that an answer to a question?
No, I'm saying the page reference you've given me,
Yes.
I can't see what you're referring to because I've got an email from Pavneet Bajwa to Diana Tabara saying they rushed me to the role.
Yes. And it says at the bottom,
Oh, okay, to the bottom, sorry.
just wait for the question really. Sorry guys, I'm just trying to navigate a series of emails.
I think you can understand Mr. Mahmood's problem because there tends to be quite a lot of narrative before a question comes.
I know. It's only because we're dealing with matters that he wasn't
Yes.
directly involved in that I'm giving him the context, and I think that's fair to the witness. That's right. Yeah, so the way to deal with this is this way very quickly. On the 12th of November, 3685, top of 3685, please. Mr. Barra, to your line manager, referring to the discussion that they'd had with Ms. Al-Najjar and Ms. Badra about the potential impact of Project ICEE on the claimants on your role. Mr. Barra asks your line manager when he expected you to be put at risk of redundancy, 3685, and Mr. Long will explain that the intention was still to change your role to the new role at this point. And he replied to Mr. Barra confirming that he had attended a meeting led by Mr. Groot the previous day about the CFCC restructuring at the regional level, and that is 3684. Bottom of 3684, please. And he says at the bottom there, we are refreshing our team target operating models now. We some further detail info in certain areas. That would then go through assessment by Manu. That's Emmanuel de Groot, isn't it?
It is.
And then be put to the Group CFCC ICEE Project Committee for review, challenge and approval. Then we would execute. And then at 3684, Mr. Long confirmed that he believed the at-risk stage would happen in January of 2020. Yes? So at the bottom, isn't it? Yes, sorry, that's right. Yeah. And then the evidence trail stops there in relation to this matter because Mr. Long says Project ICEE was ultimately postponed until the following year for a number of reasons, and that principally included COVID-19, which meant that the matter didn't progress at that stage.
Was there any question arising
Now,
from all of that?
Yes, thank you, Judge. Having looked now, being aware now of this particular email traffic that was going on, you don't have any direct knowledge, do you? Which might suggest that any of that was not the case. In other words, you've got nothing to suggest that what is said in these documents at this time is not true.
No, I was just...
Yeah, okay. That's probably the easier question to put to you. Let's move on then. Now to more direct questions involving you. This now is the subject of your 2019 performance appraisal and the decision that you would be put on a performance improvement plan. Now, Mr. Long had expressly set out the certain areas for you to work on in your 2018 P3 objectives, didn't he?
Mr. Long, you mean my objectives?
Yes, your objectives in your 2018 P3, page 4185.
That's the appeal against my...
Beg your pardon. I've been given an incorrect page reference. Just bear with me. 4760, please. Yeah. So at 4760, we see your 2018 P3 and the objectives set out therein, don't we?
Yes.
At the top of 4760, in that box, 4 lines down, we see the following 2 objectives: consideration of blind spots and self-reflection of different approaches based on stakeholder feedback, and better consideration of unintended consequences to challenge and adapt approach where needed to ensure the actual message, stroke substance, becomes a discussion and not the approach surrounding it. And we looked at that yesterday. Do you agree those are your 2018 or your objectives for 2019?
No, so that's part of the manager's assessment of my performance. That's not an objective. If it's in the section.
Did you not, when you read that, did you not think of that as a recommended area for improvement over the next year that your manager was recommending?
I saw that as something that my manager assessed. That's not an objective. So objectives are very defined in terms of P3 deliverable targets. That's an assessment.
Okay. Were these areas that you should focus on if you were to improve your performance? Can you not even agree with me on that?
As I said to you yesterday, I think so.
Yes or no? Can you agree with me on that?
Mr. Long put these in as areas that he thought I needed to improve on. Yes.
Thank you. That's the answer. We can move on. Now, throughout 2018 and 2019, you and your line manager, he will say, had many discussions about you adopting a less confrontational approach. Do you agree?
I disagree.
And we dealt with that yesterday, I think, at some length. And he says he did so because he wanted to help you to engender a better relationship with the business unit. Do you, and I think you also disagree with me that he emphasised throughout this time that creating a stronger relationship with the business was an imperative if you were to demonstrate strong value-added support for the business unit. Do you also disagree that your line manager had conversations to that effect repeatedly with you?
Repeatedly? No, he did not.
And I think your evidence yesterday was that he only did it the once. Is that right?
Yeah.
And that was in the 2018 performance appraisal.
Yes.
Now, he recorded in his manager's assessment of you in the P3 for 2019 at 4771, please. Now, this is a page of your 2019 performance review. It starts, I believe, at 4770, and at 4771 we have your manager's commentary. And can I ask you to look at what he says there, doesn't he? You can see where the bullet points and the indented paragraphs appear.
Yes.
Our end of year 2018 P3 discussion and my 2018 manager assessment expressly set out the following areas for Shiraz to work on in 2019. Do you see that?
I do.
And those are the passages I took you to a moment ago.
You did.
Judge, does the court have that?
Yes.
Reference?
Page 4771.
Correct. And then we see that he says this: throughout 2018 and into 2019, Shiraz and I have had many discussions, not limited to P3 discussions. So what he says here is directly contrary to the evidence you've been giving yesterday and today, that outside of your P3 discussion there was any discussions about this matter. And he says many discussions, not limited to P3 discussions, about a less confrontational approach that will engender a better relationship with the business, and that creating a stronger relationship is imperative to being able to demonstrate strong value-added support for the business and perform against objectives. I've tried hard to support Shiraz in building a stronger relationship with the business. We have had detailed discussions about certain emails and verbal engagements and how a different approach could be taken to make the relevant point and move forward on the relevant issue without minimising any risk or control aspects, and that calls by senior management for challenge to the status quo can be pursued in ways that limit confrontation. At times there has been progress in the ways of working and strengthening the partnership component of the CFCC/business relationship, but there always seems to be step backwards, and where an approach taken on a risk and control aspect of the CFCC is taken by the recipient as aggressive and confrontational. There has been some positive stakeholder feedback from certain members of the Islamic banking business, but the goal needs to be to improve engagement across all relevant stakeholders, as is critical to enabling anyone in a CFCC role to demonstrate strong performance and create positive feedback from all key partners and stakeholders. So your line manager is committing to writing here in your formal annual performance appraisal document that there have indeed been many detailed discussions about adopting a less confrontational approach outside of P3 discussions. Do you see that?
Over the course of 2018 and 2019.
Over the course of 2018 and 2019, yes, many discussions. But you say, if we understand you correctly, that is untrue.
I'll say it again, yes, that's untrue.
Mr. Mahmood, these reports were the process is that these reports are shown to the person they relate to, aren't they? So you got this report shortly after it was written?
Yes,
Yes.
once the performance review was concluded, it was sent.
Yes, thank you.
Well, your Honour predicted my next question.
Sorry,
But that's
sorry,
fine.
I should leave it.
I may not have got the answer in the same way. So that helps me to speed on a little bit more then. Your manager's assessment was that you still had material areas of development which needed to be addressed by you in order to become an effective member of the compliance function. Do you see that?
Are you talking about the assessment on 471?
Yes, 4771, yes.
If it's written there, then I take it as read.
And he concluded that a P3 rating of 4D was appropriate for you for 2019, didn't he? That was your rating in 2019, 4D.
That was my rating for 2019.
And he didn't do this, it seems, without running it past others, more senior. He shared his 4D rating with Mr. de Groot and Mr. O'Donnell, and all of whom felt a 4D rating was reasonable. 3736 is the page reference. Let me just find the exact, I think it's another chain problem. let's take the stage in the proper order. So on the 26th of November, no, I don't think that's right. It may be that there's not a page reference at the moment. But let me move on. So on the 26th of November 2019, he says after he had provisionally decided on the 4D rating, he received an email from you containing the 365 feedback you had received. And that was at page 3712.
3712.
Yeah. You said, Adam, I have cut and pasted below the 365 feedback that I've received. And that feedback was positive for you, which Mr. Long says did cause him some reason to reflect upon his provisional 4D rating. And then we'll hear from him as to why he maintained his 4D rating, but that is what happened, didn't it? He maintained a 4D rating for you.
He did.
But before doing so, he wanted to ensure that his 4D rating was fair in the light of the positive feedback in the 365 that you'd received. And on the 26th of November, he relayed his concerns to Miss Al-Najjar at 3711. Can I ask you to go there?
I'm there.
So 3711, bottom of the page. He says, I could use your advice. I have entered a rating of 4D in the P3 system for Shiraz. The rating is based on my assessment that he has not completed all objectives in the system set out below, and based on the verbal feedback of key business stakeholders throughout the year and my own observations of the way he works, despite my attempts at coaching. Do you see that?
Do you see that?
Objectives, and then he sets that out. Let's read that out. Create global compliance manual for Islamic banking compliance, not complete. Launch the bridge site, complete, but was a delivery that crossed 2018 and 2019. Revise the compliance risk framework to incorporate Sharia risks set out below, not complete, though not entirely within his control. Improve the content of the PPGs, not complete. Can you just tell us what the PPG stands for?
I can't remember the precise mnemonic, but that document is a kind of governance document that covers products.
It's not any of the matters that we've so far covered in evidence, is it?
No, it's a generic governance
I understand.
document, business related.
And then support the Islamic banking business on their strategic initiatives, not complete, based on the fact I have not received any feedback from the business to indicate any valued contribution. Over the page, I have socialised my 4D rating with Manu, Chris O'Donnell, my direct manager, and stakeholders in Group CFCC. All feedback is that this is a reasonable rating of performance. However, in chasing Shiraz this week for his own self-assessment and for 365 feedback, there is nothing currently in the system. He has now provided me with a cut and paste of feedback below. The feedback is positive, which would normally make you worry, as it is not aligned to my 4D rating. But as I cannot see the feedback in the system myself, and it is from only 4 people, none of which are from the Islamic banking business, and at least one person may be biased, and my overall view is that I should not be concerned that the feedback below would be a substantive challenge to my rating. And Ms. Najjar responds to him, confirming that she considered a 4D rating to be reasonable in circumstances where you had not met your objectives and were involved in an ongoing disciplinary. That's 3711, top of the page. And Mr. Long confirmed your 4D rating for 2019. And so let me actually ask you a question now in relation to this chain of correspondence. Seeing what you know now about how your 4D rating is referred to, at least in this contemporaneous correspondence. The question is, again, within your knowledge, you have no reason to dispute the veracity of these communications, do you?
The veracity of the communications.
The truth of them.
I do not have any knowledge to dispute the veracity of those communications.
I see. Yes, so I don't need to give you a page reference, we've been to it already, it's 4771, which is the rating for D. Now, in early December of 2019, that is when the meeting for the performance appraisal took place and you were informed of the 4D rating, that's right, isn't it?
I can't remember the precise date, but I was informed of the 4D rating.
And now my question is this to you. At that meeting, when you were informed of your 4D rating, Mr. Long explained to you that despite the significant amount of feedback and support you had received from him, both your performance and values required development and that a performance improvement plan should be put in place. That's right, isn't it?
He informed me that a PIP, a performance improvement plan, would be put in place.
He explained to you also that despite the significant amount of feedback and support you'd received, both your performance and values required development.
I disagree on the feedback and support, but...
No, it's whether he said this to you.
No, yeah, I disagree that he said that.
Okay. So he just said you're going to be putting on a performance improvement plan,
he
did he?
said because of the feedback from Islamic banking, negative feedback that had been persistent, he was going to put me on a PIP.
Well, we disagree. Now, as a consequence of your 4D rating, you were not awarded any variable compensation for 2019. That's right.
That's correct.
It was a consequence of 4D rating. A straightforward, automatic result.
Yes.
It wasn't the result of any discriminator's decision to give you no variable compensation. It was a consequence, wasn't it, of the 4D?
My understanding of the 4D is that you don't get a bonus.
Good. Because 4D stands for, the 4 is for improvement required, and the D is for only sometimes for some, in terms of meeting values and objectives. Let's then deal with the performance improvement plan point that you seek to complain about. Now, Mr. Long, it was his decision, wasn't it, to suggest that that a performance improvement plan, a PIP, should be implemented. Yes?
It was Mr. Long's...
It was Mr. Long's decision
Yes.
that there should be a performance improvement plan.
Based on the feedback you received, yes.
And he will say that what was driving this was his desire to help you find a way of working with the GIB business to create a solid partnership that would enable you to effectively support the business and deliver on your objectives. Now, the point of a PIP, you understand, don't you, to be that, to help you do your job better, where all other informal coaching has not quite worked. It becomes a formal coaching process, doesn't it? It's a question, Mr. Mahmood.
Ms. Sessi, my response to that is this whole P3 process did not follow the group standard. I did not believe it to be...
My question is about what a PIP is, Mr. Mahmood. You do know the question. I know you do.
Well,
you're a very articulate, intelligent man.
Up until Mr. Long...
The purpose of a PIP, listen to the question, the purpose of a PIP is to formalise a coaching process to improve your performance in any areas of perceived weakness. Yes? You'd agree with that?
I'll take your word for it.
Why do you have to take my word for it? Isn't that the point of a formal performance improvement plan? It's a formal performance monitoring improvement, formal coaching process. It's written down, it's measured, it's discussed. Yes, steps are reviewed. It's closely supervised. Do you agree that that is the point of a performance improvement plan?
The reason I have difficulty answering that question is because I've never been put on a performance improvement plan. One was never implemented, and I was never given any objectives to follow.
Let's cut this short. What on earth did you think Mr. Long was referring to when he was suggesting that you should be put on a performance improvement plan? What do you think that meant?
That my performance needed to be improved, I would be measured against it. If I did not meet those measures, I would be exited from the organisation. That's what I thought it meant.
I won't press you further on it. You can all take a view. Now, you didn't ever, you weren't actually, subjected to a performance improvement plan. It was never commenced, was it?
No, it was not.
Matters overtook. And the reasons for that, you can question Mr. Long about. Now, just very briefly, at around this time then, we know that Mr. Mahboob was conducting a review. So let's deal with the Mahboob review matter. On the 28th of February, we know that Mr. Mahboob wrote to your manager. And Mr. Mahboob, as you understand, is the regional head of an ER for Greater China and North Asia and Hong Kong.
He is.
And he's based in Hong Kong.
Yes.
And he informed your manager for the first time on that day that he was reviewing certain concerns and had been doing so from outside the region so as to manage any potential conflict of interest. That document is at page 4126. Again, similar question. You have no reason to dispute within your knowledge that this was Mr. Long's first notification of this Mahboob review.
Nothing within my knowledge.
Now, Mr. Mahboob requested your manager's feedback on 3 specific areas. One looks at his email, 3 points numbered. 1, during 2019 P3 conversation with one of your direct reports, Shiraz Mahmood, around end of November, did you inform him that you would be initiating a PIP against him? Have you actually initiated a PIP? 2, I understand Shiraz's role is going to change significantly, and as such, the changed role will be open for application within compliance chain. Who has approved this proposal? 3, you are probably aware that Shiraz has previously raised concerns on multiple occasions. While considering PIP, if any, or potential redundancy situation, did you ensure any additional safety measure so that the actions are not perceived as victimisation due to his raising concerns? Now, on the 29th of February, your manager responded to Mr. Mahboob in an email with his feedback. That's at page 4125. I'll ask you to go to that document.
Thumbs up.
Do you need a moment to read that document, to remind yourself of what it says?
I was never privy to it, but I'll read it now. Thank you.
three propositions come out of that. Firstly, you accept, don't you, that he confirmed to Mr. Mahboob that he had not initiated your PIP
He did.
because of Project ICEE. Secondly, that 2 weeks previously he had discussed with HR the option of entering into a mutual separation agreement with you. Yes?
He mentioned the MSA.
Mentions the MSA here.
Yep.
And he considered that that would achieve the fairest outcome. And thirdly, he confirms that whilst discussions had taken place about the restructuring of the GIB compliance role, your role, he deliberately did not want to accelerate the changes because he did not want to create the perception that you might be being victimised by having your role changed before the other regional compliance roles were reorganised. Do you see that?
He states that.
Now, he also asked Mr. Mahboob, didn't he, here, whether he was investigating a specific grievance or complaint against Mr. Long personally. Because, he asks that because if that were true, then Mr. Long would not wish to initiate the PIP. Do you see that?
No, I can't. Can you point me to it, please?
Yes, I know. 4126, second paragraph. It's the second paragraph on the second page. Further, please confirm if your queries are part of an ER. Do you see?
Yes, I see that.
Thank you. He also tells Mr. Mahboob here that he intended to notify his managers, Mr. De Groot and Mr. O'Donnell, of Mr. Mahboob's queries to him, unless Mr. Mahboob said not to do so. Do you see that?
I do.
And Mr. Mahboob then responds on the 29th of February, page 4124. He says, he confirms that his review was not based on specific concerns raised against Mr. Long. He asked Mr. Long to keep the matter confidential, and he said he had no concerns about Mr. Long not initiating your PIP. Do you see that?
I do.
And he responded at 4124, top of the page, or middle of the page, your line manager is now saying to Mr. Mahboob that he will not update Mr. De Groot and Mr. O'Donnell unless he's advised that he can, and he confirms that he will continue discussions with HR about the MSA. Do you see that?
I see that.
Now, having seen that email chain, again, is there any reason within your knowledge to dispute these documents as accurately setting out what happened at the time?
Yes, I don't disagree with the content of a lot of those documents.
You said you don't disagree with the content of a lot of those documents. You don't agree?
I don't agree with the content, much of the content in those emails.
And is the reason why you do not agree because the content is fabricated?
Let me just go back.
They say what they say. So what is it about the documents that you say is questionable?
The process followed one, and yeah. So in terms of this email from Mr. Long to Mr. Mahboob, it's
Tell us precisely which email you're referring to, please.
page 4125.
The email timed at 3:53 p.m.
That's correct.
Yes?
I understand what's written there. I am concerned with the content of it, so I disagree with aspects of that.
All right. Well, you're not being at all clear with me, so I'll move on. You
if there are separate questions here. One, does the witness consider these emails to be fabricated, false, or in some way not authentic documents?
He's been asked that question.
Question number two, does the witness agree with what's being said in the emails? And the concern I have about question number two is I'm not quite, and it's a very broad question. We've been looking at some very long emails, and I'm just not sure what the witness, in terms of his own testimony, is meant to say or not say.
The witness knows that when I'm taking him to these documents at each turn, documents to communications with which he was not privy at the time, but he is now aware of, in circumstances where he's bringing a behind-the-scenes conspiracy allegation against a dozen or so, more than a dozen people, that we're seeking to understand what he says, whether he says a document is fabrication in the first place. I don't think he's saying that, are you?
I'm not saying that
You didn't answer that
documents are
question
fabricated.
directly. You said you had a problem with the contents, to paraphrase your answer, and I asked you what content, and your answer was unclear. It was because I didn't ask you about. I asked you to identify the content that you have a problem with, and your answer was not clear. Can you please identify the content?
Mr. Sessi, if...
Can you please identify the
When
content?
you say identify the content, what do you mean by
You
that?
took us to an email when, in your answer,
Yeah.
and you said you had a problem with that email, 4125.
Yeah.
So what is it in that email which is not true
I do
within
not-
your knowledge?
I do not believe that the way this is presented by Mr. Long as being driven by Project ICCE and the reasons for not putting me on a PIP are valid as stated in that email.
So your evidence to the court is that when Mr. Long is saying, giving this response to Mr. Mabou, that he is lying.
That's for him to testify.
No,
but
no.
I don't-
What
I-
is
I don't
you're
disagree.
raising the fact that you think something in this document is not true,
Yes.
and you say that when Mr. Long makes references to the ICEE matter, a reorganisation, that is not true in this document. That's your evidence, isn't it?
In relation to my role, yes.
Right. Other than speculation, Mr. Mabou,
It's okay.
Mahmood, I beg your pardon.
It's
It's Mr. Mahmood and Mr. Mabou. What you have no knowledge to gainsay what's in this, what's being communicated at this time, do you? You've got no reason to dispute this, have you?
My case will be put forward due course.
No, it's your evidence, it's your knowledge. I'm asking you a question about it. It goes to the heart of the case. Are you going to answer the question?
What's your question, sir?
Pardon?
I've answered your question.
If you feel you've answered it, I've given you a fair opportunity. I'm not going to labour the point.
I think he did agree that he had no evidentiary basis for the assertion. You accept that, don't you, Mr. Miller?
Yes, it is my belief.
I need to trouble him no further on the topic. Let's then move on to the mutual separation agreement issue. Now, your line manager says that he started discussions with Emma Crooks, global head of ER, about the possibility of entering into a mutual separation agreement in around February 2020. And he says it was his idea to propose it. Do you have any evidential basis in your knowledge to disagree with that?
I haven't seen the correspondence, but no,
Just yes or no, please.
I have no evidential knowledge on that.
I see. Now, he indicates that we've already seen that throughout the first half of 2020, no, sorry, let me just rephrase that. He will give evidence to the court that throughout H1 of 2020, he had various discussions about the MSA option with Ms. Crooks and with local HR in the UAE, Ms. Al-Najjar. The fact that he was in discussions with Ms. Crooks and Ms. Al-Najjar in the first 6 months of first half of 2020, you don't dispute, do you?
It was not, to my knowledge, I wasn't aware of it, so I can't dispute it. Wasn't aware.
And he will say that he explained to them that he did not consider there to be a realistic prospect of you finding a way of working with the GIB business to create a solid partnership, and that he had spent a lot of time trying to manage you, and that he had explained that to HR at the time. So again, you've got no reason to dispute that.
I wasn't privy to the discussions.
I wouldn't have expected you to have been, but that's helpful in terms of just narrowing the factual disputes in a highly fact-sensitive matter. On the 2nd of June 2020, he says he discussed the option of entry into an MSA with with his line manager, Mr. O'Donnell, who was supportive. You've got no reason to dispute that, have you?
No.
But that's when he informed Mr. O'Donnell, and Mr. O'Donnell was supportive.
I don't.
He says he asked Ms. Tabara to provide him with some details of the methods which would be made, so the payments details which would be made to you under the MSA. Again, you've got no reason to dispute that.
None.
And he says on the 6th of June 2020, he attended a call with Ms. Tabara, Ms. Al-Najjar, Ms. Bajwa, and Ms. Al-Rashdan, Mr. Al-Rashdan, all from HR. You've got no reason to dispute that?
No.
And he says it was unanimously agreed that the MSA was a sensible way of trying to reach an amicable resolution. Let me just take this in stages again. When he says that there was a unanimous agreement at the meeting, you weren't at the meeting, but you've got no evidential basis to dispute that.
I have not.
He says he then received some information in relation to payment details from Mr. Barr on the 8th of June. That's at page 4305 to 4309. We don't need to go to that, but that's the reference for the record. And then on the 11th of June, he says Mr. de Groot confirmed to Mr. Al-Rashdan that he supported the decision to propose an MSA. That's at page 4374. Can I ask you to go to that? So, do you see that on that page, 4374?
I see it.
So on the subject of the MSA, we're agreed, aren't we, that the evidence indicates it's your line manager's decision. He's consulted 4 members of HR, quite senior members. He's consulted his line manager and his line manager's line manager. Yes?
Agreed.
Thank you. Now, it was on the 24th of June, wasn't it, 2020, that the proposed MSA was provided to you?
I
Is that
can't
right?
recall the precise date, but it was provided to me.
And is that because it was given to you in person?
No, it was during COVID. We were all in lockdown.
I see. Yes, June of 2020. And you then asked for more time to review the offer and take legal advice, is that right?
That's correct.
We see a reference to that at page 4446. And on the Yes, I think Mr. Al Rushdan and Mr. Barra had given you until 5th of July to provide a response. Is that right?
I can't recall the precise date. Originally, I believe the letter gave me 24 hours. I challenged that, and there was some discussion around dates.
Yeah,
I
but
can't recall.
it was the HR people, Al Rushdan and Tabara, that gave you an extension of time until the 5th of July.
I had to write to Mr. Long first.
Right, but they gave you the extension, didn't they? Well, you were given an extension
I was given
until
an
the 5th of
extension.
July. We can all read the documents. On the 2nd of July 2020, were you aware that Mr. Long's position was that he was fine with giving you as much time as you needed to complete a review of the MSA?
I believe that to be accurate, yes.
You believe that to be accurate? And the page reference, Judge, is page 4452. It's the second entry. I am fine with giving him as much time as he needs to complete a review. Do you see that? So Mr. Long wasn't trying to rush you, was he?
No, he wasn't.
You then wrote on the 2nd of July at 4476.
It was 476.
4476. You send an email to Mr. Al Rashdan copying in your manager and Ms. Tabara,
Yes.
saying that you were unhappy that you'd not been provided with sufficient time to review the MSA because there'd been a delay in you being provided with paper copies of the document and because you had been busy at work. Just so I'm clear, did this cross with Mr. Long's response that you can have as much time as you need?
I'm just reading it for me.
I'm just checking on timings with different people. With international times on emails, sequencing can be quite difficult at times. Now, while we're just checking for this page reference, on the 10th of July, we can see that Mr. Barra wrote to your manager, updating him in relation to the ongoing discussions with you, page 4442 to 4443. Did you go to that? 4442. And what occurred was that Mr. Barra, let's just cut this short again, Mr. Barra had told you that she would seek internal approval to extend the deadline for acceptance of the offer to the 12th of July. That's right, isn't it?
442, I can see an email from Emmanuel.
Yeah, 4442 to the 4443.
Okay.
Yes, those two pages. She had told you that she would seek approval to give you an extension to the 12th of July. Yes?
Here's the bit about I'll extend the offer till 12th of July. Yes, it's
Got
written
it?
in the
Good.
email. Yeah.
I am trying to short circuit
Sorry,
quite turgid emails, and I understand it can be difficult to.
Can I just say, look, I'm
read.
really sorry. It's day 3. and my brain's a bit fried, so I'm not being as quick as I can be,
That's
so
fine.
I apologise.
I understand, Mr. Moon.
That's understandable. Then, let me just see where we are at. Mr. Long will say that it's Mr. Barra who here is seen to be informing him of the outcome of your disciplinary appeal, that your appeal had not been upheld. Now, given the nature of your case, do you accept that, well, you have no reason to dispute that Mr. Long is right when he says this is how he found out about the outcome of your appeal? Mr. Barra informed him. Yeah.
I have no idea how he found out about the
Indeed.
outcome of the appeal.
Indeed. Okay, thank you. That's clear. What then happens is on the 11th of July 2020, your manager sends an email to Mr. Barra. No, sorry, he forwarded Mr. Barra's email to Mr. de Groot and Mr. O'Donnell by way of updating them, page 44-42. He said to them that he would ask HR to advise on next steps if you did not sign the MSA by the following day. Do you see that?
Yes.
Good. Then 19th of July, he asked Mr. Barra for an update. She replies that the deadline for you to accept the MSA had been extended to the 15th of July, but that you had still not responded with your decision.
19th of July.
4451.
I see that.
Good. And then he she says that you will be added to the list of redundancies for the September window. Mr. Long will say in evidence that he understood Mr. Barra to be referring to potential redundancies because no decision had been taken to make you redundant. You were to be included on the list of at-risk redundant employees due to Project ICEE.
Where are you reading from now?
That will be Mr. Long's position.
Right.
Again, do you have any evidence, any knowledge of any matter to suggest otherwise?
What will be his position? Sorry.
He says that when Mr. Barra says in this document at 4451 that you will be added to the list of redundancies for the September window, he understood Mr. Barra to be referring to potential redundancies because no decision had been made to make you redundant at that stage. You were to be included on the list of employees at risk of redundancy. So what she's referring to there, he says, is to be placed on the list of employees to be placed at risk of redundancy due to Project ICEE. You've got no evidential basis to dispute that.
Well, I do recall, you take me through a lot of emails.
I have.
And one of the ones you took me through, there seemed to be, there was a predetermined decision before the IC model was going to be, I think there was Mr. O'Donnell and Mr. de Groot.
All right. Well, I've identified the emails. We may have gone through them at some pace. I've asked you the questions I want to ask you. Your barrister will have a fair opportunity to re-examine you on any matters, so long as they strictly arise out of my questions. Now, let's move on then to redundancies neatly, because we know, don't we, that it was decided that as part of the global reorganisation of the group's CFCC advisory teams, that what had been decided was that there was going to be they were going to align seniority of roles at the regional level. All lead FM CFCC roles in regions would become a band 4. So let me make that clear. All lead FM CFCC roles in the region would now become a band 4. You understand that that was what was decided as part of the global reorganisation?
wasn't privy to it, but if it's documented...
But that's your now present understanding, isn't it, of the global reorganisation process, insofar as it impacted upon your region?
Based upon what?
Based on what you have now read from the respondent's evidence.
Okay. So if it's documented in there, and that's the rationale the bank's given, it's documented.
I see. And what was going to happen was that the incumbents, those presently in any MD roles, there would have been an opportunity to apply for new roles or seek alternative roles within the group. Yes?
Again, you have to
Again.
say something
Oh,
before
sorry.
I move. We won't get it on the transcript.
I beg your pardon, sir. Mr. Sethi, if it's set out in the documentation, I take it as read.
Okay. I suppose, Judge, the point is the defendant's evidence and descriptions of this Project ICEE redundancy process, this global process, you don't dispute the accuracy of their evidence in relation to when they describe that there was this big redundancy process going on, the object of it, the purpose of it. You don't have no reason to dispute the genuineness of the global ICEE redundancy process.
Project IC was going on.
Yeah.
My case would be, and I don't want to get into argument, but my case would be that yes, it was a genuine process, but in relation to myself, I thought it was used as a lever to accept me from the organisation.
Yeah, I understand. That is, we do understand that.
But in terms of, there was a genuine IC project going on globally.
Yeah. In other words, there were lots of other people being made put at risk, or being made redundant, or being made to apply for roles as a result of a genuine reorganisation.
Would this be a convenient time, Mr. Sethi?
I think so, yes.
That's all right. We'll adjourn until 2 p.m.
Thank you.
All rise.
If you could get that, I'll look at the draft and hear it now. I'm going to be working on the re-examination. If you could get any sandwich from Brett or whatever, tuna, and maybe could you get one of those funny sort of cereal bars? You know, they're called. No, it's the love. It's either the love bar or there's a funny popcorn bar. They do popcorn and chocolate, and a Sprite. Sprite would be fantastic. Thank you. I will look at this and crack